there has been no better time to talk about where the Supreme Court is going and what is happening to the Supreme Court than now. And if you are finding it a challenge to teach your students about what's going on in this court, you are not alone. It has baffled my generation of undergraduate law teachers. From what I read, it is baffling the current law professors who are teaching our law students. And what I hope to do today is to give you some direction that I have followed to try to figure out a way to talk to our post-millennial students about not only the history and the evolution of the Bill of Rights and the Constitution and the changing nature of the Supreme Court, but the dramatic difference that we are seeing now. I would recall for you a story I heard when I was an undergraduate, which was about a half a century ago, that right after the court packing fight of 1937, one of the great law professors, I think it was at Harvard, came into his class and he had an armful of all of his case books. And in front of his class, he walked over to a giant trash can and he dropped all the case books into the trash can with a thud, looked at the class and said, "That's what's done to our past in constitutional law. Now we're going to start again." And so he tried to explain to them where the court was going. What I'm going to try and do in this session, and I have a lot to cover, so if you don't mind, if you have questions during the lecture, if you could put them in the chat and Beth can remind me of them, I'm going to try and just complete what I have prepared so that we can get through it. And I'll be happy to stay as long as you wish. I know there's a hard stop at 9, but I never leave questions unanswered if you want to stay after that. And I'm getting smiles from people who have worked with us. They know that has happened. I want to try and give you a foundation so that you can get more out of our next 3 speakers. We have remarkable scholars to talk to you. Keith Whittington of Princeton will be talking to us about the First Amendment and free speech. He's written an extraordinarily useful book for teaching about free speech. And he will be also talking about the jurisprudence of Samuel Alito. Graham Lee, an emeritus professor of St. Joseph's University, one of our international experts on American freedom of religion, will be talking to us, tracing the changing nature of the freedom of religion from the Waite Court in the late 19th century to the current day and predicting what will be happening in the future. And then our final speaker, Helena Silverstein, my department head at Lafayette College, is one of the nation's experts on abortion law. She will be talking about the Dobbs case and what might or might not happen to the substantive due process area. So we will have a great deal to offer you in the next several weeks. I'm going to start with the Second Amendment, because what I'm going to try and do is illustrate all the things that I'll be talking about today in a brief examination of the modern gun rights cases of the Roberts Court. The Second Amendment reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Now, you notice that there are 2 commas in that sentence, and there's a lot of debate about whether there were any commas when it was first written, whether it was 1 comma, whether it was 2 commas. I'm informed by Pauline Mayer's excellent book on the ratification of the Bill of Rights that the sentence actually comes from a letter written by James Madison. This and the black powder musket, that's what the framers were thinking about when they were talking about the weapons of that time and what weapons you should keep and bear in order to be able to be part of the militia. And that you know what the weapons look like now. And we have to talk about the way that the Supreme Court changes its interpretation of the Second Amendment and how it affects the nature of the gun rights and gun laws that we have now. Next slide, Beth. So the question I really wanted to start with was, when did the Bill of Rights become, all caps, the Bill of Rights? When did it become the main term of art that everybody understood as the nature of American freedom and the heart and soul and foundation of American democracy? Professor Maglioka, he's a law professor, makes a very interesting argument that, that this actually happened, the changing nature of the term of art, in the early 1900s when we had Philippines become part of the territorial United States. And there was a lot of discussion in that administration about taking each one of the Bill of Rights as written and then applying them to the Philippines, which was in fact done. And he said from that point on, the Bill of Rights became a very important concept for the American people. Next slide. That didn't seem quite the full story for me, because I had been told that the actual nature of the Bill of Rights changed dramatically in 1938, when the Caroline Products footnote 4 was written after the court packing fight, and the court began the whole process of diminishing their power, dealing with the Commerce Clause and the power of Congress to pass legislation. And looking for something to do, they decided that they were going to spend more time looking at the 14th Amendment, Due Process and Equal Protection Clause, and all of the Bill of Rights. And the debate was really joined at that point as to whether or not the Bill of Rights would apply to the states. Next slide. Now, since that time, as you all know, because you've been following this in the news, the Supreme Court has found its public legitimacy being questioned, and there are many calls for reforming the Supreme Court. Its popularity and its public support has been declining dramatically. As you can see on the left of this slide, these are Gallup poll numbers. The Supreme Court job approval was normally in the mid 60% range. It had actually gone down to 62% because, as you know, it follows Bush v. Gore. But the public approval had rebounded after Bush v. Gore, after a quick drop. But you can see that there has been a steady decline all the way down to 40%. And that was in late 2021. And I believe I saw some numbers on some of the polling that dropped it down into the 30%. And one of them, I think I remember, was close to 25%. It is very, very almost precipitously low job approval rate. But it's more revealing to look at that drop in job approval with the increase in the disapproval of the way the Supreme Court is handling its job. And notice that in the 2000 era, you had a gap of 62% approval and 29% disapproval. So you've got 33% positive. Look at what happens in late 2021. It drops all the way down to the court being underwater. Its approval is at 40%, and its disapproval is at 53%, a negative 13% rate. These are fluctuating. We'll see what happens this year, but it seems to indicate to everybody that the Supreme Court's public legitimacy is something that they need to do something about, and they are in a very precipitous kind of situation with respect to the calls for reforming the Supreme Court. Next slide, please. Marquette Law School has been doing a lot of public polling on the Supreme Court, and you can see that their results mirror what we saw in the Gallup poll. You had an approval rate of 66% in 2000, and a disapproval rate of 33%. So it was a positive 33% rate. And it's dropped all the way down now. They're actually bouncing back a little bit. In the early part of 2023, that should be 1/11/2023. In that week of 2023, their approval rate was 47%. Their disapproval rate was 53%. They're still underwater, and that's most unusual for them. When we look at this court, the court has been changing direction in terms of its ideological voting pattern. Next slide, please, Beth. What I've tried to do here is map the way the court has been balanced all the way up to 2022. From 1972 to 74, all the way through to 2021, The court was largely a 4-1-4 court. Now, there's an exception in the early 1990s because you had kind of a shifting nature of the median voting of the court. It wasn't clear whether Souter would be in the middle. It wasn't clear whether Kennedy would be in the middle. It wasn't clear whether O'Connor would be in the middle. Souter should be there. And he would probably be, in this era, he would probably be in the middle. I don't know where Souter went. At any rate, the difference now is we have a court that is not balanced. It now has 6 conservative votes. We're going back to the opposite of what we had in the Warren Court in the 1960s, where you had 6 liberal votes and 3 conservative votes. And it's hard to figure out how to graph it in the 2022 period. A more accurate reflection, I think, would put Kavanaugh with Thomas, Alito, Gorsuch, and Barrett. And Roberts would be sort of in the median, but he's still on the conservative side. You have a court that is so conservative that the 5 more conservative voters, Thomas, Alito, Gorsuch, Barrett, and Kavanaugh, can actually do whatever they want in terms of voting, regardless of what the Chief Justice Roberts wants to do. So you'll see a lot of articles talking about how Roberts has lost control of his court. And I have made the argument on other occasions, and I still hope and believe that this will be the case, that Roberts's play in this term may well be to find ways to entice Kavanaugh to come over and vote with him. Kavanaugh's been voting with him over 90% of the time so far. And I think there's a possibility that what we might be seeing eventually is a 3-3-3 court. It might be possible that you will see Thomas, Alito, and Gorsuch on the conservative side, not Breyer, that would now be Ketanji Brown Jackson, Kagan, and Sotomayor on the liberal side, and then possibly Roberts, Kavanaugh, and Barrett in the middle. Or you might see Barrett stay with the conservatives, and it might be Roberts and Kavanaugh in the middle. I think that's one of the things I'll be watching for in the term and the terms to come. That sort of interpretation comes from the following data. Next slide, please, Beth. There is a remarkable resource online called the Martin Quinn, Quinn scores, done by Lee Epstein, a professor at University of Southern California, USC Law School, and also I think she's at University of Washington at St. Louis, Andrew Martin and Kevin Quinn. And what they do is they take all of the votes of the justices and they measure whether they uphold previous precedents or strike the precedents down. And they found that there is a remarkable coincidence between the votes on overturning or upholding precedent and the votes as to whether or not a justice is liberal or conservative. And so what they do is they get a single statistical number for the justice for that year. And if the number is in a positive level, that's a conservative vote. And it can range as high as 4 or perhaps 5 on the positive side. If the number is a negative number, that's a liberal vote. And you can see that Justice Sotomayor is just a little bit over -4. And that's considered very liberal now. But if you look at the historical data online, you will see that I think Brennan was in the -5 or possibly 5.5. And Justice William O. Douglas was -7. So this is a more conservative court than it's been in the past. And then if the number is at flat 0, it's neither liberal nor conservative. So you're looking at the median voting of the court. When you take these numbers, and the numbers are outlined for the 21-22 term, and translate them to a continuum, that's what the court looks like. It's an interesting thing because if you go back a couple of terms, Roberts was closer to 0. He was closer to more 0.5, and he was very close to where Kennedy was, who was a little bit to his right, and also where O'Connor was, she was a little bit to her left. So you had Roberts in the middle, along with Gorsuch, Kavanaugh, and Barrett, but that kind of groups them together in a way that's not really pretty accurate. When you look at the frequency in the majority of the justices, the three justices who seem to be voting mostly the same are Roberts, Kavanaugh, and Barrett. Gorsuch seems to be just a little bit more on the conservative side, so he's more frequently voting with Alito and Thomas. And then you have, now remember this is 21-22, so you don't have Ketanji Brown Jackson there. You had Breyer and Kagan closer to the center, and Sotomayor on the far left. So there you can see the 3-3-3 orientation of the court, and it gives us a sense of where the court might be going in the future. Next slide, please. Now, here's the problem. When I start my constitutional law classes, I have a set series of memos and lenses.
About this summer.
Can we mute ourselves, please? I have a set series of lenses and memos and how to brief cases, a set type of cases that we study to try to understand how the Supreme Court has done their work over time. That material I put together for you, it will be in the Google Drive for memos for you. And that just doesn't work anymore, because this court has gone in a direction unlike anything we've seen in my lifetime. And I think it hasn't happened ever, to be honest with you. So I'm going to try and show you briefly what the court is doing now. And there'll be more memos in the Google Drive that will help you to understand it. And then we'll take a look at how the court has evolved over time and finish with what they're doing on gun rights now. Next slide, please. Here's the issue. The six justices, especially the five most conservative ones, know that their time as an overwhelming majority of the court may be limited. And anything can happen to the court. There can be changes in personnel. There can be changes in decision-making. And so they seem pretty determined to accomplish as much as they can, as fast as they can. And there seems to be a hit list of precedents they would like to overturn. You all probably know one of those precedents that I didn't list here, the Janus case in 2018, dealing with agency fees and the unions, the governmental unions of teachers and so forth. And the way that the court dealt with that, and the way that the court dealt with other longtime precedents prior to Barrett coming to the court, made it clear that they were simply not going to be governed by the use of precedent and not going to be governed by the concept of stare decisis, let the previous decision stand. So we have seen many, many comments by Clarence Thomas and Neil Gorsuch that they wanted to do something with New York Times versus Sullivan, the libel case for government officials and for public figures. It has been clear from some of the things that they have said and written that they would love to do an overturning of Scalia's opinion dealing with the free exercise of religion in 1990, Employment Division of the Department of Resources of Oregon versus Smith. It is also clear that this group would like to end the separation of church and state and have a total accommodation of the government with church and with religion, Lemon versus Kurtzman. You're seeing the beginning of a process that may lead to the overturning or substantial changes of what's known as the Chevron doctrine, Chevron USA versus Natural Resources Defense Council Incorporated. It's a doctrine in which if an administrative agency makes a ruling about how some kind of law should be implemented or wants to create some kind of program to do that, the Chevron doctrine has been telling the court that they should defer to that agency unless it's an unreasonably or irrational type of action. It's pretty clear that there are justices on this court that would like the Chevron doctrine to be overturned. And those of you who read the concurring opinion by Clarence Thomas in the Dobbs abortion case, and Professor Silverstein will be talking about this in detail, know that he targeted the entire substantive due process area for reconsideration, mentioning in particular same-sex marriage rights, same-sex intimacy rights, and the question of incorporation of the Bill of Rights has also concerned him. And he also mentioned the issue of reproductive rights, dealing with contraception and so forth. So these are all sort of on the hit list of where the court would like to make their contributions in overturning precedent. Next slide, please. When you look at that hit list, you understand that what the court seems to be doing is they will pick an area of law, they will pick a case that they want to overturn, they will accept an appeal, and then they don't do the conventional, what has the court done in the past in certain cases? What are the precedents? Instead, what they seem to do is they use their own interpretation of history. Alito calls it history and tradition. Thomas calls it historical understandings. Gorsuch calls it historical and practical understandings. It's basically history as read by that justice and ratified by 4 other justices to give them a majority. They will use their own reading of history. They will push themselves back in time to when that first major precedent was issued, and they will, almost like in a time machine, put themselves on that court and then make an argument that that was an incorrect decision, that it was wrong, that it needs to be overturned. And that's not how law is supposed to be made, but that's how they're making it. And looking for some kind of philosophy for how they're going to use history and tradition, they seem to have a penchant for coming up with 3-word phrases or theories, many of which have been debated or argued at the Federalist Society, and use that as a mechanism for developing their narrative for why law needs to go in a dramatically different direction. When they wanted to overturn the decision by the EPA to change the nature of the power plants to renewable energy, what they did is say the EPA doesn't have the authority to make this kind of decision because it's an important political question. When they wanted to change the nature of the ruling about the importance of free exercise of religion and upgrade free exercise of religion to be sort of a super right and give it absolute protection, even in the face of other rights by other people who would be discriminated against because of the exercise of free exercise of religion, they came up with an international relations phrase called most favored nation, and argued that there should be most favored nation for the treatment of the free exercise of religion. And the case I hope that you will be watching very carefully, obviously we're all watching the affirmative action case coming out of Harvard and the University of North Carolina, but Harper versus Moore, dealing with the nature of gerrymandered districts by a legislative judgment in North Carolina, is going to be very, very important for whether or not the court adopts the independent state legislatures theory and the argument that state legislatures should have total control and should not be reviewed by any other group or any other level of government or any other agency, and they should have total control over the nature of districting and voting rights in that state. Could I have the next slide, please? Clearly, this is a very different approach to how the court has been deciding cases. And so I spend a lot of my time, and I'd be happy to discuss this in questions, trying to figure out, Lafayette is on the verge of celebrating their bicentennial in 2026. We were established in 1826 by the people of Easton, Pennsylvania. And I often sit and wonder, those who were teaching at Lafayette, if they were teaching law, which lessons for that Supreme Court are most like the kind of lessons that I am trying to teach now? And I started with, well, I'm probably teaching like they taught in the 1930s, the late 1930s, after the court packing fight. And I decided after a while, no, I've got to go back further in time. So I went back to the 1890s, around the time of Lochner versus New York in 1905, decided I had to go back farther than that. I ended up back in the Reconstruction after the Civil War period, and the issue of the legal tender case, the Greenbacks case, was that the time that we saw a court that was so conservative and so willing to overturn precedent and so political in their decision making. And I decided that maybe that was the time, but I didn't think it quite covered the dramatic shift of the nature of the balance of the court. So I'm currently back in 1835 to 1837. Next slide, please, Beth. 1835 to 1837 is when John Marshall had just died, and Andrew Jackson, who couldn't get Roger Brooke Taney confirmed as an associate justice, took his ally, states' rights, his Secretary of the Treasury, who had allowed him to break the National Bank, and nominated him to be Chief Justice, and was able to ram that through the Senate. And then, because he was able to fill 2 additional seats on the Supreme Court, and he was able to then fill 3 more vacant seats on the Supreme Court, in about a 2-year period, he ended up appointing 6 justices to the Supreme Court. It was a complete reversal of what the Federalist Court had been under John Marshall. Now it was a states' rights court, and it was designed to undo everything that Marshall had done. So what you're seeing here, and I can speak about this on a different time, is the outlines of a theory offered by Professor Maglioka again. Here's a wonderful book on Jackson and the Constitution, and another wonderful book on William Jennings Bryan and the nature of constitutional reform. And he has come up with this idea of kind of constitutional generational tipping points. There are points at which the court is the center of a battle of 2 waves of political thinking, a new sort of reform wave and the older establishment wave, and they start battling over policy and control of the presidency and control of Congress and control of state governments. And after this battle is fully joined, eventually these issues become legal issues. Eventually they find their way to the Supreme Court. And more often than not, one side and or the other side try to rig the system by attacking the Supreme Court or changing the membership of the Supreme Court or changing the size of the Supreme Court. It's a very dramatic kind of battle that takes place. And I particularly like Professor Maglioka's work on this, because he was trained as an undergraduate by somebody who knew military strategy. And that's basically how Maglioka writes. He knows all the law, he knows all the history, but he's framing that narrative around the kind of things that Clausewitz or Sun Yat-sen would talk about, the nature of the center of gravity of forces and the battles that can take place in war. So you understand the forces that are coming to kind of compete over control of the Supreme Court. Next slide, please. When I describe it that way, to me, I think we lost one slide there. When I describe it that way, can we go back one slide, Beth? When we describe it that way, okay. When we describe it that way, we have a court that has been in transition and been in battle since 2016. When Antonin Scalia died suddenly, it was at a time that he could have been replaced by Barack Obama. And what many people didn't understand at the time is, had Barack Obama been able to fill that seat, still got to go back one, had he been able to fill that seat with Merrick Garland, for the first time in about 50 years, the Supreme Court would have had a majority of Democratic president-appointed justices. It hadn't happened since back in 1969 and 1970. But when Garland didn't even get a hearing, and when the seat was kept open for 10 months, and Neil Gorsuch was then nominated by President Trump, and then when Mitch McConnell led the Republicans in the Senate in the process of eliminating the filibuster for Senate confirmations of Supreme Court justices, and Gorsuch was able to narrowly be confirmed to the Supreme Court. And then when Anthony Kennedy retired from the court in 2018, and Brett Kavanaugh replaced him on the Supreme Court. And when Ruth Bader Ginsburg died suddenly just before the presidential election in 2020. And suddenly the same Republican majority that couldn't make a decision about filling Scalia's seat in 2016 can do it now lightning fast just before the election so that Amy Coney Barrett is able to come to the Supreme Court. You have now 3 new Trump appointments to the Supreme Court, and you have 2 of them under very unusual historical circumstances. This, to me, is the essence of what Maglioka is teaching in these 2 wonderful books. And that's why I think that the nature of the comparison of the period that we are teaching about now is so unusual that we would have to go back to professors and teachers who were teaching in the late 1860s, hope that maybe there were still people alive who were teaching in 1835 to 1837, and have a seminar with those people and say, well, what did you do? Here's my solution. I've scrapped everything. And my problem is, I know how the story ends when I'm dealing with students who are just starting out in the classroom. They're very excited. They want to learn cases. They want to learn concepts. They want to learn about legal doctrines. They want to learn how the Supreme Court operates. And that story I have been telling and teaching for 5 decades now. And I know how to do it. But I know that in the end, they're going to do more than my classes have been doing in the past. In the past 10 or 15 years, we get to the Rehnquist court decisions, we get to the early Roberts court decisions, and my students say to me, but Professor Murphy, I've read these precedents, I know what they say, I see what the court says they say, and they're not saying the same thing that I know them to be. Am I wrong, or are they wrong? And then you told us we can't do these things when we're deciding cases. But the Supreme Court does it that way. Should I follow the court, or should I do it my own way? And so I always end with telling the students, make your own decisions. Then I will give you a chance at the end of your essays or the end of your term papers to say, okay, now what would the current members of the court say about what you're doing? Well, we're not even doing that anymore. Now I'm teaching them all of these precedents, knowing that in the end, I'm going to say, remember everything we did between week 9 and week 13? Forget it all. It doesn't matter anymore. It's been totally wiped out. I am not making this up. I was trying to file the files from the different weeks that I teach in the First Amendment case law. And I had in my hand a plastic file box filled with everything in the freedom exercise of religion and the Establishment Clause. And looking at all of those Establishment Clause files, I realized that if something were to happen and suddenly all those files about the Establishment Clause would spontaneously combust so that I only had the Free Exercise Clause files left, it wouldn't matter, because they all pretty much have been eliminated by the Kennedy versus Bremerton School District case. That's our challenge. We have to teach our students that they're not following the rules on the Supreme Court. They are now historians in robes. They are political historians in robes, and they're going to make the decision they want and then put together their version of history and try to convince people that they have the correct interpretation, when they're going to have in dissent somebody like Justice Kagan or Justice Sotomayor, who are going to do all the things that we've done in our constitutional law class and say, here are all the cases they're ignoring, here are all the legal doctrines they're ignoring. They're not doing what they're supposed to do. You should follow what we want to do and not what they want to do. But we only have 3 votes, so it's going to be a while before we're able to do it. In a nutshell, if you look at the Janus opinion, that's what you see. You see Alito saying the original decision back in 1977, the Abood versus Detroit School District case, that was wrong. And because that was wrong, I'm going to replace it with new doctrine. I'm going to uphold the freedom of speech rights of people who don't want to pay the agency fees even though they're not a member of the union, to allow the union to lobby for them and to say things in political fashion that they might not agree with. The game that I play here is whether or not Scalia would sign on to what the current court is doing. Would he agree with the results? Yes, he would. But would he sign on and say, yes, just throw the phrase history and tradition out, or historical understandings, or historical and practical understandings, because that's the way I understand it. I honestly and truly believe that Scalia would not sign on to the opinions that way. He would write his own concurring opinion. Because Scalia's view, and I wrote a book on Scalia and follow the evolution of his thinking. He doesn't always use his originalism theory. He doesn't always use it in a legal sense. Sometimes he uses it to get the results that he wants to get. But his notion was, in theory, what I'm going to do is I'm going to go back to the founding era, and I'm going to limit my power by looking at what the founding era's original public meaning was of the words at issue in this case. I'm going to go back to the state ratifying conventions, and I'm going to look at the dictionaries of the time, and I'm going to figure out what did the people understand the word militia, the word regulated, the word keep, bear, arms. What did they understand those words to mean? And then I will put together a theory of where I can go with the interpretation of the Second Amendment. He would not pick and choose in the way that is done in the Bruin case by Clarence Thomas. He would not just say, historical understandings, I'm going to go through every government regulation that has ever been created, including in Tombstone, Arizona, which was the cause of the gunfight at the OK Corral. You all know that from watching the different movies and reading about that. The Earp brothers believed, or were told by the sheriff, Johnny Behan, that the Clanton gang had disarmed. They knew it not to be true. And they went to the OK Corral knowing that the only reason they had guns were they had badges. They were deputies. But the Clanton gang shouldn't have had guns at all, and yet they were heavily armed. That was a government regulation. And there were government regulations all around the country over the 200 years of our 230 years of our history. But every one of these regulations, the historical understanding of the justice on the court with the agreement of the other conservatives on the court, Clarence Thomas, he said those are outliers. Those are unique. Those are not to be followed. And he was called on this by Stephen Breyer in dissent. So you have a historical originalism theory countered by the living, evolving constitutionalism of people like John Paul Stevens, who say what we need to do is we need to look at the precedents of the other members of the Supreme Court and try to figure out how the words have evolved over time so that it's a living constitution. Next slide, please. So what are they doing? Here's the answer. Samuel Alito. As the court has reiterated time and time again, adherence to precedent is not an inexorable command. Clarence Thomas, we use stare decisis as a mantra when we don't want to think. And here's what they don't want to follow. Next slide, please. What they don't want to follow is the plurality in the Planned Parenthood in Southeastern Pennsylvania versus Casey decision dealing with the abortion regulation in Pennsylvania. Anthony Kennedy had told David Souter, Harry Blackmun, and Sandra Day O'Connor that he was switching his vote and he was now going to vote to uphold Roe v. Wade. We will learn much more about that in Professor Silverstein's talk. They're not really upholding Roe v. Wade per se, they're upholding Sandra Day O'Connor's version of Roe v. Wade. And the reason they were going to do this is all three agreed that this was a 19-year-old precedent. Remember that Janice was a 41-year-old precedent, and there was no reason to overturn the 19-year-old precedent. So they're upholding the precedent of Roe v. Wade. They're not saying if I was on the court in 1973, I would have voted this way. It's just going to be upheld because this has been a long-standing legal doctrine that has been upheld. And their argument is rather straightforward. If the rule in that earlier case is still workable, if people rely on that rule, if the new rule is not coming because an old rule is just abandoned, it's now an anachronism and it needs to be swept aside, or if the facts of the new case are so different from the facts of the old case that it completely makes the old rule unworkable. If these things are not true, we will not overturn an earlier precedent. Next slide, please. Brett Kavanaugh doesn't completely agree with that. And he argued in a case dealing with juries, talking about a case going back to the 1960s and early 1970s, dealing with the nature of juries. He said that he would be willing to overturn precedent if it was not just wrong, but egregiously wrong. And then he argued that you would have to look at that prior decision and ask, have there been negative jurisprudential or real world consequences from it? And then he said that he would want to be sure that overruling the precedent wouldn't upset people who rely on this precedent. So when you look at Roe v. Wade and realize that we're talking about nearly 36 cases that are getting wiped out in Dobbs, it's difficult for Kavanaugh to make the decision that he does. He's worried about that reliance factor. But I don't want to talk so much about Kavanaugh because he didn't write the opinion in Dobbs. I want to talk about Alito. Next slide, please. Alito has a very different approach. He's trying to accelerate the precedent clear-cutting, as I call it, in all of these cases, especially in Dobbs. He uses the concept that Kavanaugh offers, the nature of the court's error, and he asks, is it egregiously wrong? But then he says, I'm also going to basically grade the quality of the reasoning in the precedents. If I think the reasoning isn't good enough to pass my exam, I'm not going to uphold it. And then he talks about workability and the disruptive effect of the precedent on other areas of law and concrete reliance. What is he talking about? What is Thomas talking about? What they're talking about is, I have no obligation to uphold precedent if I believe that if I were on the court when that original precedent was issued, I would think that the court's judgment was egregiously wrong and that the reasoning that's used for that precedent is not to be believed, not to be followed. And so what the two of them do is they use their own version of history. And this is a longer discussion for a different lecture. But what they both do is say, I'm going to go not necessarily to the founding era. I'm going to go to the 14th Amendment proposal, passage, and ratification era, and the period right after the 14th Amendment, the period from 1868 to 1870. And what I'm going to do is I'm going to compare what the interpretation of that right was in 1868 to 1870. And then I'm going to go back in time and I'm going to see whether or not there is a good reason to overturn this precedent by looking at what the founding era's understanding was of that right. And then Alito says, I'm going to go back to Old English history. So you have him talking about the 1868 understanding of abortions as outlined by Justice Kagan, cross-matched by the 13th century when there were witch cases in Old England. Thomas, however, doesn't think he should go back to Old England. He's going to spend his time looking at the time from 1868 to 1870, cross-matched by the founding era, and then looking at the period of time from 1868 to the end of the 19th century. That's pretty much where we are. We have a court that is willing to just use its raw power to overturn decisions using their version of history, ignoring the rules of precedent, and simply saying, I have the power now to declare those precedents egregiously wrong and not well reasoned. And the power that I'm given to do that is that there are four other people who are ready to overturn this precedent with me. Beth, can we turn off the slideshow? Great. So that's a quick review of what I have to do to get my class to this point. What I want to do is somewhat shorten my evolution of the Bill of Rights argument to give you a sense of where we're going to end up on the gun rights in 2008. You know what the blunderbuss looked like. You know what the muskets look like. The question is, how do you get that Second Amendment to apply against the states? And how do you interpret the Second Amendment? And for the court, it was a very difficult process because John Marshall in 1833 had said in Barron versus Baltimore, the Bill of Rights do not apply against the states. And he argued simply, partially, I was the head of the ratifying convention of Virginia, so I know what people thought of the Bill of Rights, and I know that they intended for them to be a check on the central government, not a check on the states. And I also look at the Bill of Rights, even though we proposed 17 of them, but only 12 were sent to the states. And what is now the First Amendment was actually the Third Amendment that the states considered. The first two dealing with the right of the Congress to increase its salary for that session of Congress and the size of a congressional district. The First Amendment begins, Congress shall make no law. And so I cannot say that I will apply any of the Bill of Rights to the states because it doesn't say no state shall abridge freedom of speech or freedom of religion. All of that changes with the 14th Amendment Due Process Clause, because John Bingham, when he proposed it, along with about a half a dozen of his colleagues in Congress, thought that they were going to be able to overturn Barron versus Baltimore using the 14th Amendment. But what they were going to use was not the Due Process Clause. It was the Privileges and Immunities Clause. They believed that the privileges and immunities was a shorthand for all of the Bill of Rights, that they were the main privileges and immunities that needed to be extended to the states. That was not made possible in 1873. The Supreme Court decided in a Louisiana slaughterhouse case that the privileges and immunities only meant national privileges and immunities, not state privileges and immunities. And so we began the process of, is there a way to apply the Bill of Rights to the states? And the answer was proposed in a series of cases that maybe you could use due process of law. Maybe you could see due process not as a procedural right, what is fair, but also as a substantive right, what is wise. And if you could use the wisdom and the substantive due process aspect of the 14th Amendment, maybe you could argue that certain rights were in fact necessary to protect people's freedom at the state level. Now, when you look at the period of time from 1873, when you have the slaughterhouse case, to 1938, when you have the Caroline Products footnote, you don't have a lot of courts saying that the Bill of Rights in any part or any form apply to the states. You have them saying in 1897 that the eminent domain provision of the Fifth Amendment will apply against the states, but it's John Harlan not really calling this incorporation, but talking about the fairness and the decencies of life, talking much like he is writing the Declaration of Independence, because he knows that's the only way he can get the votes of all the other members of the court who do not want to incorporate any of these rights. Harlan is the only one arguing, as Bingham did, that the purpose of the 14th Amendment was to incorporate all of the Bill of Rights, and no one agrees with him. You have to go all the way forward now to 1925, when finally the court begins to incorporate, and they incorporate the freedom of speech provision. But they don't use it to protect Samuel Gitlow, who's an anarchist. They're thinking, maybe I can use it to protect corporations who might not want to tell people why they're firing their workers. So they're setting up the possibility that we will incorporate, but we're not going to incorporate to protect people's rights. We're going to incorporate to protect corporate rights. What really gets the court to understand that they have to do something is the Scottsboro Boys case in 1932, Powell versus Alabama. Here you have several young African Americans away from their family being accused falsely of a capital crime they did not commit, with a hostile crowd, a hostile judge, a hostile jury, a press that's looking for a conviction, with a mob outside. And all they get is one lawyer who is designated to be their representative, talks to them for less than 30 minutes, and then they are facing the trial in that town, and all of them are convicted. Even the 9 old men of the Hughes court couldn't stomach that. But this is not the incorporation of the right to counsel. Court didn't want to do that. Instead, they created a right that you won't find in the Constitution and you won't find in the Sixth Amendment or the Bill of Rights, the right of fair hearing. They said these young men were denied a fair hearing, and so we're going to overturn this conviction. We're going to send it back for retrial. Eventually, these young men were pardoned, but many of them were long gone by the time that happened. And the court in the end said, but I'm not going to create a right of fair hearing for everybody. I'm only going to create a right of fair hearing for a case just like this one. So when Mr. Brady in the late 1940s in Maryland said, I would like counsel because the Scottsboro Boys got counsel, the judge says, no, you're not anything like that case, and I don't have to do that for you. You don't see the court extending the right to counsel until 1963 in Gideon versus Wainwright. It is a long, slow, torturous process. Where I focus with my class in this process is in those 1930s cases. The way we used to have to teach was you go straight to Palco versus Connecticut. The argument by Palco is, I won my case. I was convicted of manslaughter. I was not convicted of first-degree murder. Now the state wants to retry the case because they say under Connecticut law, a mistake or mistakes were made by the judge and I should get a retrial. But that would be double jeopardy for me. And he's right. But the court is saying, no, but double jeopardy has never been incorporated and applied against the states. And so you explain to your students, this is what Cardozo did. What he said is, I'm going to invent a concept called implicit in the concept of ordered liberty. I'm going to ask whether or not the double jeopardy provision is the foundation of democracy. Is it the matrix, the indispensable condition of our society? You go through all of that philosophical understanding and they get it. And so then they understand that from that point on, it's selective incorporation. The court will either say that a right is implicit in the concept of ordered liberty, or they won't. And then they come to understand that Palco didn't even really win his case. The only thing he got was a place in history. His name is known, but he was retried and he was convicted and he was put to death. But that's an incomplete story for this court because they don't really use Palco. They don't really use Duncan versus Louisiana in 1969, when Byron White has to explain why they're incorporating the right of a jury trial, when in fact, Cardozo had said specifically that the right of jury trial in 1938 in Caroline Products footnote is not implicit in the concept of ordered liberty. And so what in footnote 14 of the Duncan case, what White explains is, I'm going to look at the American system of ordered liberty. I'm going to look at the Anglo-American tradition through the states. What he's telling us is, I'm going to start with Palco and Cardozo. I'm going to look at the next 31 years, and if it looks to me like the states have begun to adopt this portion of the Bill of Rights, I'm going to declare it to be implicit in the concept of ordered liberty in 1969. That is what he does. That is why the jury trial is incorporated. That is why the court then goes on to say that 10-2 verdicts and 9-3 verdicts are going to be okay at this point because they still represent a larger diversity of society. And that's the case that Kavanaugh is talking about. He doesn't think they are full precedents because they were not majority opinions. They were plurality opinions. And he is setting up the argument that we will be able to overturn the Casey decision because it's a plurality opinion. But he doesn't have to worry about ever making that argument because they now have 6 justices, and Alito is using his history and tradition and using his clear cutting of precedent and declaring Casey and Roe to be egregiously wrong with bad reasoning, so he overturns it. But the process by which they get there tells us that what this court is doing is something more than that. And so I would urge you to take another look at Snyder versus Massachusetts. It's a case that isn't talked about much, and it really revolutionized my teaching. At some point in all the decades that I taught the Roe v. Wade, I eventually went to my wife and said, you know what, I've been teaching this too long. Rehnquist is starting to make sense to me. And it forced me to go back and reread those earlier, that earlier case and carefully look at the footnotes. And I realized that what had happened was that Harry Blackmun, in upholding the right to choose an abortion, in upholding substantive due process, he began his opinion with a case called Botsford. And the Botsford case back in 1895 said that there is a right of personal autonomy, privacy, and control over one's own body, so that the judge could not force a woman who was suing for damages from a railroad, he could not force that woman to be examined by one of the railroad's doctors. Horace Gray didn't want her to have to remove her clothes to a foreign individual in which she has no longer got any bodily control over her own privacy. And so what Blackmun's doing is he's connecting that right of personal autonomy, privacy to the Palco implicit in the concept of ordered liberty decision. But Rehnquist doesn't want to reach that result. And he never mentions Botsford, and he doesn't talk about Palco. He goes to Snyder. Snyder is 4 years before. It concerns a defendant who is told by the judge that the judge is going to take the jury to visit the scene of the crime. It was a robbery and murder at a gas station. Snyder really wants to go. He wants to make sure that there's a correct interpretation. And the judge says, no, your lawyer will go. You don't have any constitutional right to go to the scene of the crime on a field trip with the jury. The lawyer comes back and tells Snyder, this is what the judge said. Snyder says, oh, no. When that happened, there weren't that many gas pumps. The number is different. And no, confessing to his lawyer that, yeah, I was there and I did it. But also that error happened and claiming that's why he might be convicted. So that case comes to the Supreme Court. And the argument that they're going to make is you have no right to go to the scene of the crime because we are looking at all the earlier precedents that say there's no procedural criminal justice right that we've incorporated and applied against the states to this point. And that's correct. There was none. And then the argument is made, in order to understand whether your right is fundamental, we have to look at the traditions and consciences of the American people. The traditions and consciences of the American people. What is that justice saying? That justice is saying, I'm going to do a survey, I'm going to see what the state laws have said, and I'm going to ask myself, have the states ever given people that right? That justice does that survey and says there is no right here. The justice who is writing that opinion just 4 years before Palco is the same author of Palco, Cardozo. Cardozo is saying there is no history and tradition here. And in dissent, Justice Owen Roberts, who doesn't really dissent in this way very much, and certainly doesn't take on Benjamin Cardozo, and certainly doesn't beat him in an argument in this way. He says, wait a second, what about the liberties and decencies of human life? What about the fairness here? You've got to look somewhere else. Maybe they haven't incorporated this right at the state level, but we should. And what I show my students is what actually is happening is Cardozo is overturning Cardozo in Palco. That's his view. But Rehnquist ignores Palco. He goes right to Snyder, and that becomes the basis of his judgment. And if you look at the argument of Samuel Alito in the McDonald gun case as to whether or not the gun rights will apply to the states, he uses Snyder, but does something extraordinary. He adds Snyder to Palco to Duncan and somehow concludes that that is the new rule for interpreting whether or not to apply the gun rights or any Bill of Rights to the states. It's a long way of getting to this point. What has actually happened in the gun rights area? What happened is that Antonin Scalia in 2008 argued that he would ignore a 1939 decision by William McReynolds, very conservative, also an originalist of a sorts. He argues that if you look at McReynolds' opinion, when McReynolds says you only have a right to keep and bear arms if that gun was used in the military, and he argues that the sawed-off shotgun used by this bank robber was not used in the military. Yeah, that's an incorrect interpretation. You all know that the blunderbuss looks exactly like a sawed-off shotgun. You all know probably that they used sawed-off shotguns in 1917 and beyond in World War I in the foxholes because that was your best defense against somebody coming into the foxhole. But McReynolds says, I'm going to interpret the Second Amendment as being a right only if you're dealing with a gun-issued type of weapon. And I don't think the sawed-off shotgun is one of those weapons. Scalia is saying, I'm going to ignore that precedent. I'm going to look not at the well-regulated militia being necessary for a free state. I'm going to look at the right to keep and bear arms. And I'm not going to interpret the right to keep and bear arms. I'm going to be interpreting my synonym for the right to keep and bear arms, the right of self-defense, which actually is an argument that he's making is the right of self-defense in one's home. And that's something pointed out by John Paul Stevens. He's arguing that we have an individual right to have a gun in our home to protect ourselves. Part of the reason that he does this, I believe, is because he's looking to pick up the libertarian votes of Clarence Thomas and Anthony Kennedy. He cannot get to 5 votes unless he has Anthony Kennedy. When you look at the Bruin case, what Thomas is doing is he's saying, now I'm going to ignore the portion of Heller that said the right was a gun in your home. And I'm not really going to talk about the right to carry a gun anywhere outside of the home, but I'm going to instead focus on the right of the state to regulate the carrying of a gun outside the home. And I'm going to use my history and tradition, the phrase is historical understandings, to wipe out every historical analog, that's his term. I'm not going to find any historical analogy for the kind of regulation that New York has, and I'm going to wipe out that regulation. 2 final things to leave us a little bit of time for questions. One is, when he does this, he gives no real sign to lower court judges as to how they should interpret history and tradition. And there is chaos in the lower courts and chaos in the Court of Appeals about what Thomas meant by historical understandings. And so you see laws dealing with red flag laws down in the Southwest, laws dealing with whether or not a non-violent felony convicted person should be able to have a gun, carry a gun. Laws in New York dealing with the regulation of sensitive places such as churches or zoos or places of public transport. You see at the Court of Appeals level, they don't know what to do. At the district court level, they don't know what to do because the only one who's interpreting history and apparently judging these laws on appeal is going to be Clarence Thomas. But 2, read that case again carefully and read the separate opinions of Samuel Alito and also John Roberts and Brett Kavanaugh, and a third opinion by Amy Coney Barrett. That opinion of Thomas's, it's presented as a 6-3 opinion. But when you read those three separate opinions, it makes it clear that they're not taking the full ride with Thomas. And so I think they may pay a little bit more attention to the final paragraphs of Scalia's Heller decision, the 2008 decision allowing for the use of a gun in the home for protection of one's own self-defense. He added in a couple of paragraphs that said this is not an unlimited right. Thomas is saying it's an unlimited right. Thomas is trying to argue, as they do in the free exercise of religion, that certain rights are super rights. They're almost absolutely going to be protected. But I don't think that's what his colleagues are arguing. I think his colleagues are looking at those two paragraphs in the end, where Scalia says felons may not be able to get a gun. Mentally challenged people may not be able to get a gun. Dangerous and unusual weapons may not be carried. He's arguing for restrictions of this right that he's created for Heller. And when it reads somewhat differently from the rest of the opinion, I believe it is John Paul Stevens in one of his books who pointed out that, in fact, those paragraphs were drafted by Anthony Kennedy. That was the price that Kennedy asked for to sign on to Scalia's opinion. So the question would be, did Scalia actually believe that? Would he actually be voting with Thomas? And the more current question is, do Roberts, Kavanaugh, Alito, and Barrett also believe that? What will happen when these other cases come to the Supreme Court? Will Thomas be able to hold that majority? That's what I'll be watching for. I'll close with this. My students are very, very confused in the beginning when I tell them, as they're looking forward to applying to law school and going to law school and thinks that these courses are their stepping stones to law school, when I tell them that we're going to be looking at these cases in the most modern era at the end of the course, and we're going to be doing something other than law. And you're going to be in a position to be arguing with these justices based on your understanding of these issues. And they do, and they can do it very, very well. But they understand what I'm saying when I tell them you walked into this room with what you thought was a cap that said pre-law. Take that cap off and put on your cap that says government or political science, and wear that cap as well. And think of these justices as politicians with robes on, exercising their legal decision-making power, and you'll have a better chance of understanding what they're doing and where the court might go next.